Ethical public liability. What do you know about public liability? It is insurance coverage which shields people or companies from lawsuits resulting from property damage, personal harm to third parties or other associated responsibilities. If someone is injured or their property is damaged and the insured party is held legally liable for the damage, this insurance is intended to provide financial support. First, insurer, known as the insurance industry big assistant. Regular payments to the insurer in the form of premiums are made by the business owner. Assistant in the event of an accident such as injury sustained on company property. The role is to investigate the incident, determine liability, and then assist in making things right by covering any injuries or damage. And the objective is to maintain everyone's satisfaction. Second, insured, individual or company receiving the coverage. If something goes wrong, insured must notify the insurer straight away and cooperate to receive the issue. Type of insurance. Ethical public liability insurance is designed to protect businesses and individuals from the financial consequences of legal liabilities arising from their business activity. It involves coverage for bodily injury or accidental death caused to individual not employed by the insured party. If customer slips and falls on a wet floor within the insured premises, so it will cover legal liabilities including medical expenses. Limitation and exclusion. The liability of the company is subject to specific limits mentioned in the schedule. Exclusion. Deliberate acts contractual liabilities not inherent to the insured. And specific property damage exclusion. Condition and clauses. Various conditions and clauses are outlined such as including notice requirement for claims. Condition for termination of the insurance policy. Premium must be paid and received by the company within a specific time frame. Failure to do so may result in automatic policy cancellation. Risk insured. Legal responsibility for harm or death done to third party. This may consist of client injuries. A client breaks their arm after slipping and falling on your shop floor. Second, unintentional damage to property of third parties. Fire damage. Your neighbor's fence sustains damage when a welding spark from your workshop ignites a fire. Third, legal liability for funeral costs resulting from accidental death. Medical expenses which pay for the cost of treating the wounded person, such as surgery. Then, premium. The public liability policy premium is computed using estimation provided by the policyholder. Within 1 month at the end of each insurance period, the insured must also provide the insurer with any details and information that the insurer may want. Exclusion help to specify the parameter of coverage and restrict the insurer's responsibility in particular situation. War, terrorism, nuclear accidents, pollution are not covered by the insurance. As a conclusion, public liability insurance is vital to risk management as it provides a strong financial and legal defense against unexpected third-party claims. That's all from me. I hope you understand very well. Thank you. Bye.
Next, for the parties' argument, the court rulings emphasize the importance of the obligation of greatest good faith in insurance contract, avoiding false representations, and revealing all relevant facts. The defendant proved that plaintiff had not shown enough evidence to support life insurance coverage and the presence of specific policies of a material facts. The court accepted the defendant's testimony, emphasizing the ramifications of the first responder silence and the implications of evidence and party conduct in insurance claims litigation.
Assalamualaikum warahmatullahi wabarakatuh. My name is Fairunisa binti Muhammad Fadili. My meeting number is 065508. So today I'm going to tell about the fact of the case for the case of Joy Liking vs Prudential Assurance Malaysia Berhad. The plaintiff The wife of the deceased life insurer filed a lawsuit against Prudential Assurance Malaysia Berhad after the insurer liquidated claims for 2 life insurance policies held by the deceased. The policies had a sum assured of 2 million each, and the plaintiff was named as the nominee. The insurer alleged that the deceased failed to disclose 3 existing life insurance policies with AIA Berhad, which is totaling 3.5 million each. During the application process for the Prudential Assurance policies, the defendant argued that the non-disclosure of these policies was a material fact, and they had been aware they would not have issued the PAMB policies. The central issues were whether the defendant could repudiate the deed claim and declare the Prudential Assurance policies null and void from their inception due to fraudulent non-disclosure or mispresentation by the deceased. Next, the court in its finding emphasized the duty of utmost good faith on the part of the life insured, requiring full disclosure of material fact. The court referred to the Financial Services Act 2013, FHA, specifically Schedule 9, and noted that a life insurance contract exceeding 2 years in force could only be avoided if the insurer demonstrated that a statement pertained to a material matter and was fraudulently made. The court found that the existence of the 3 AIA policies was a material fact, and their intentional non-disclosure constituted fraudulent misrepresentation by the deceased. The plaintiff failed to prove her claim, and the defendant was entitled to repudiate the claim on both Prudential Assurance policies based on fraudulent non-disclosure. The court dismissed the plaintiff's claim and awarded cost of 50,000 to the defendant. That's all from me. Assalamualaikum.
Judgment in this case, which is life assured, was the plaintiff, who was Tan Po Ling's wife. The plaintiff presenting her claims for 2 policies that the life assured had purchased from the defendant. The defendant rejected the claim and proclaimed that the policy had been void from the beginning. This was due to the life assured purported fraudulent non-disclosure and suppression of material facts at the time of the 2 policies were purchased. As a result, the plaintiff sued the defendant to recover 2 Rm4 million life insurance that the life assured had purchased and for which she had been designated as the nominee. According to the defendant, the life assured neglected to reveal his 3 pre-existing AIA policy in PAMB Proposal 1 and 2, even though he was fully aware of them at the time he applied for PAMB Policy 1 and 2. The defendant further argued that the existence of the 3 AIA policy was a material fact because the defendant would not have issued the 2 policy, which is with a total sum assured of Rm4 million. At the time, if the existence of 3 AIA policy with a cumulative coverage of 3.5 million had been disclosed to the defendant prior to the issuance of the PAMB Policy 1 and 2. The defendant rejected the plaintiff's claim and decided that PAMB policy was void from the beginning. This was due to the previously mentioned, which is fraudulent omission, suppression, and mispresentation by the life assured. Consequently, the defendant denied the death claim and sent a letter dated August 6, 2020 to the plaintiff advising of the decision. The plaintiff filed an appeal with the defendant on August 13, 2020. Nevertheless, on October 20, 2020, the defendant later rejected the appeal. Hi, Assalamualaikum. My name is Nur Nadira Ashira binti Shamsuddin. So, the issue regarding this case is between Chong Lai Kang, appeals against Prudential Assurance Malaysia Berhad, or whether the defendant has the right to reject the plaintiff's death claim, which was made under policy numbers 351-92844 and 3520115. This policy had been in effect for more than 2 years prior to the death of the life assured, and whether the plaintiff is entitled to the remedies requested in Division 1, Part 3 of Schedule 9 of the Financial Service Act 2013. Whether there was a mispresentation by the life assured by not disclosing the existence of the 3AIA policy, and whether the life assured had committed fraudulent non-disclosure of the statement of claim filed herein. So, the judgment.
Assalamualaikum. My name is Aizat bin Zayaya. My matric number is 060344. Today, I would like to share about my part, which is holding for the case in Chong Lai Keng versus Prudential Assurance Malaysia Berhad. Based on true analysis of the relevant facts and legal prospects, the court issues multiple crucial rulings in the Chong Lai Keng versus Prudential Assurance Malaysia Berhad case. The court found that the life assured failure to disclose 3 current AIA policy was a relevant circumstance that affected the underwriting choice. It came to the conclusion that the deliberate withholding of this policy from the application process for prudential insurance amounted to dishonest deceptions and omission of material fact which violated the obligation of the highest good faith. The lifeguard guarantee swiftly reported prior policy from 2005. Therefore, the court deemed it improbable that he or she would forget or neglect policy's prospects only a few weeks prior, especially given the sizable coverage sum at stake. The court applied and construct pertinent parts of the Financial Services Act 2013, citing precedent such as Ulaganatan Mutia versus Prudential Assurance Malaysia Berhad and Toh Sek Cheong versus Great Eastern Life Assurance Berhad. The plaintiff's claim was dismissed and the defendant was awarded RM50,000 in costs after the court determined that the defendant had a right to repudiate the plaintiff's claim based on the 2 PANB policies because of fraudulent non-disclosure and misrepresentation. That's all from me. Thank you.
Assalamualaikum and hi. So for today, my group would like to present about Chong Lai Keng versus Prudential Assurance Malaysia Berhad. The defendant received a first PNB proposal from the plaintiff's spouse for a life insurance policy with a 2 million basic amount assured and death benefit. The life assured requests a second policy with a 2 million basic amount assured or death benefit. The defendant issued a second policy for the second proposal. The plaintiff was left as the nominee and had 7 additional policies. The plaintiff filed a lawsuit after the life guarantee passed away unexpectedly, claiming 8 different policies. The life assured held 3 AIS policies with AIA Berhad, which were already in effect when the life assured applied for the first PNB policy. The defendant rejected the plaintiff's claim, stating that the life assured failed to disclose these pre-existing policies and that the existence of these policies was a relevant fact that the life assured had fraudulently omitted or suppressed. The plaintiff life guarantee had falsely represented material facts in the first and second PNB proposals, making the policies void from the start. The plaintiff appealed unsuccessfully to the defendant, launching a lawsuit to reinstate the original and second PNB insurance. The issues involved whether the defendant could reject the plaintiff's death claim and declare the policies void.
Based on the facts and arguments presented by both parties, we may infer from the ruling that the plaintiff's judgment is not appropriate. The life assured has signed 2 policies with PANB, but not in utmost good faith, where he has several insurance policies with other insurance companies. According to the insurance concept, parties are considered to be tied to a contract without restriction after they have consented to it and signed it. The defendant may argue, as it has in this instance, that the life assured neglected to disclose the terms of the first and second PAMB policies. The court will reject the plaintiff's arguments as there is a lifetime need to behave in good faith and fully disclose any information relevant to the contract. As a result, we upheld the ruling in Schedule 9, Paragraph 5 of the Financial Services Act of 2013. Additionally, we agreed in the same sentence on the ruling on the matters that needed to be tried. The question is whether the defendant can declare the two policies void from the start due to fraudulent non-disclosure or fraudulent misrepresentation under the FSA and repudiate the plaintiff's death claim, which had been enforced for more than 2 years before the death of the life assured. In this instance, the defendant rejected the plaintiff's death claim, renounced obligation under the two PAMB policies it had given to the life guarantee, and declared the policies meaningless from the beginning. The life assured failed to fully disclose the presence of the three AIA policies valued at 3.5 million ringgit. Further, we gave in by citing the decision of Leong Kam Wei v QBE Insurance Malaysia Sdn Bhd and Os in 2006, in which it was conclusively determined that an insurance contract is one in which the parties to it are mutually obligated to act in an uberrime fides manner towards one another. As a conclusion, failing to declare all of one's current insurance policies when applying for another coverage may result in significant repercussions under insurance law. This emphasizes the significance of transparency and honesty in the insurance applications process to preserve the integrity of contractual agreements between the parties concerned.